Hey guys, I'm Jacob Blizzard, and I'm a board-certified criminal law and criminal appellate specialist attorney, and I want to talk to you guys today and continuing to talk to you about the 2255 motion and writ and talk to you about how you can make it work for you. So first off, when you're talking about the writ application and the motion, you got to follow the form. So there's a form put out by every district court in the United States and the territories that you put your claims on. You need to go to the court's website. You can download it readily available there. You can contact the district clerk to get a copy of it from the district court as well. But all of your claims or grounds go onto the form, and you fill out the form best you can and being accurate. And you want to talk about the facts outside of the record. What does that mean, facts outside the record? Facts outside the record are those that the court doesn't already know about that happened in front of the court or in front of the appellate court. So that means don't just talk about what happened in your trial. Oh, judge, you wrongly decided my motion to suppress. You should have granted it where you denied it. No, you want to rephrase that into there was additional evidence which my lawyer could have presented or additional cross-examination which my lawyer could have done, which would have made my motion to suppress successful, because that's bringing in information from outside of the record to tell the judge, oh, but judge, if you would have heard these additional things, then you would have agreed with me that my motion to suppress should be granted. I actually received ineffective assistance of counsel. That's why you denied my motion to suppress. So you're phrasing it off of the actual main issue and you're focusing it on to something like ineffective assistance of counsel. Or you're focusing it on to something like a Brady violation where the government failed to produce some exculpatory evidence that had you had that evidence, you would have been able to use it and successfully defend yourself. So those are the types of things you're putting into these grounds. You're not talking about just what happened in the trial. You're talking about things like ineffective assistance of counsel, prosecutorial misconduct, due process violations, jurisdictional issues. The constitutionality of your conviction is the thing that's in question. That's what you're attacking. Think about everything that the Constitution stands for, and then think about how that might apply to your case. So then you're using the form, but the form is not the end of the story, okay? Everyone that is a prisoner in jail and writing these things on their own, they use the form, right? Because they can, and the form is made for use. But you also should write a brief. You should write a brief in support of your writ application, your motion. You want to outline to the court that you are entitled to relief through this brief that goes along with the 2255 writ form. Because you're taking those facts that you kind of outlined neutrally in the application and you're being persuasive with them. You're telling more of the story, and you have more space to do that. You have more leeway to tell the story about what happened to you and elaborate on the facts and argue to the court why you've been wronged. So that's how you go about filing a 2255 motion. That's a start to the process in thinking about what it is that you're pursuing, how you exactly go about doing it.